And we are going to start this morning with case number 29-164, Elliott-Thomas versus Lewis. Both parties are represented by counsel, so each side will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. If you haven't been here since we added the clock, you can keep track of your time up there. I'll also try to help you out as you get close to the time that you wish to reserve, Attorney DeCilio. We do record the argument, so we ask that you stay at the podium, keep your voice up, and if there are children involved in the case, please use initials as opposed to names. The judges have read the briefs in this matter and are ready to proceed if you are, sir.
Thank you, Your Honor. Good morning, may it please the court. I would like to reserve 5 minutes for rebuttal, if the court would so note.
Very good.
Also, it's nice to be back in Summit County and arguing before this panel. First and foremost, Your Honors, this is probably one of the longer writing samples I've ever done in my legal career, probably dating back to law school. There's a lot of complex issues that are raised as assignments of error by myself. First and foremost, I guess I would start by saying I'm going to plan on touching all of them. I'll probably waive argument with regard to issue 2 because it sort of carries the same legal issues as issue number 1 regarding financial misconduct. And with that, I guess I'll begin by saying the issue raised in assignment error number 1 specifically has to do with the conclusion by the trial court that Mr. Lewis engaged in financial misconduct. And I think the core set of facts that were used to reach that conclusion are that Mr. Lewis did not file tax returns during the course of the marriage. I believe it was from 2002, 2003 to 2011. And due to that lack of filing, there was penalties and back taxes owed to the federal government. The evidence would suggest about $155,000 to the federal government and about $70,000, I think, to the state government, or $55,000 to the state of Ohio. Where we believe the error occurred is that the appropriate test, the 2-part test that is required by the trial court to apply, was not applied. Namely, there is 2 elements that, not 2 elements, but 2 parts of the test. Number 1 is that you have to find the wrongdoer engaged in behavior that would interfere with the opposing spouse's property rights. And the second element, which is really what I believe was not analyzed by the trial court, is that the wrongdoer profited or that the wrongdoer's actions stemmed from an intentional act meant to defeat the other spouse's distributions of the marital estate. The trial court, what it simply did was cite a case from the 5th District, wherein the proposition put forth by that 5th District case was that if a spouse fails to file tax returns, that in fact that qualifies as financial misconduct. And Mr. Donor, I think, cited a lot of cases that he believes stands for that proposition of law. However, the one case I cited, Bucolo, very clearly establishes by this court that the 2-part test has to be applied, and when this court reviews whether or not that test was applied or how it was applied, the standard of review is a manifest weight of the evidence standard. That being said, I think the reason the appellee needs a black letter rule to apply to back taxes is because if that rule is not black letter, this matter alone should send this case back to the trial court, because we cannot assume an analysis by the trial court on the second part of this financial misconduct test. And what I believe appellee is trying to do is substitute what this court's precedent has been with a black letter rule, and then thereby saying, because this black letter rule is what needs to apply, then there's no need to send it back. And I'll tell you in elaborate detail why that black letter rule is not the law and why it should not be applied by this court. Some of the cases that were cited by opposing counsel are a little older, and they sort of support his argument, but when you drill down on them, namely the most recent case he cited is the Sullinger case from the 6th District Court of Appeals. And he very succinctly states that this court, or that court rather, concluded that if taxes were not filed during the course of marriage, that qualifies as financial misconduct. But that's not really what Sullinger says. And if you drill down in it and read the law that they're applying, they actually apply the standard of review that this court has historically applied, and they also apply the two-part test. And so when they're conducting their review, they're reviewing it with a lens that the trial court actually applied the two-part test, number one. Number two, which is really significant in that case, is that they specifically state that the facts of the trial have to be reviewed individually underneath the two-part test. And they're essentially saying there is no black letter rule with regard to financial misconduct. And just because there's other cases where facts were different, where maybe back taxes not being filed qualified as financial misconduct, they're saying that is not the rule. And I believe it's, I would reference it, Your Honors, but forgive me, I left the case over at my desk there, but that is what it says, and I think that is paramount because that is the most recent case cited by either party. It very clearly establishes the two-part test I'm saying has to be applied, and the same standard of review, and it resoundingly rejects the idea that there is a black letter rule with regard to taxes not being filed. And with regard to the other cases cited by counsel, the facts are very different. He refers to the Gupta case. In that situation, there was a divorce proceeding filed in India, and the person, the husband in that situation, never came back to litigate the trial, and so there was also other aspects that could be used to conclude financial misconduct. And so the facts cited by each case, the facts in each case cited by opposing counsel are very complicated relative to this one. And moreover, what I would say is, now that we know what the law is, we know there's a two-part test, at the very least, the trial court never fully analyzed the facts under that two-part test. And that assignment of error should be upheld by this court, rather, not upheld, but be grounds to reverse and remand this back to the trial court.
Didn't the court note that the wife did not file returns until after she discovered the husband had not been filing for 10 years and that she experienced penalties as a result of that? So I guess what I'm saying is, in a roundabout way, did the court reach the conclusion that the result of the misconduct was harm to the wife under the test that you espoused?
Well, and the court doesn't say that. The court does talk about that issue, and there's problems with that. If we were to use that as an example to say the court really analyzed the second part of the test, we're doing two things. We're doing the trial court's job for them, which I don't believe is what is appropriate under this assignment of error. But number two, the evidence, when you look at the exhibits that was provided, it is really, there's an argument because there's not a clear piece of evidence as to whether or not it's back taxes owed or it's penalties and interest. And that's a significant difference because had they filed their taxes together, and there's some reference to it in the trial transcript, and I know opposing counsel, for reasonable reasons, did not want to go back and have his client withdraw her taxes and have them filed jointly together. But one of the cases he does cite is that there's sort of an understanding that when the IRS puts liens on, they overestimate, the penalties and taxes that would be owed. And had these parties filed together, my client would have satisfied that debt or that obligation. But because the opposing party went on and filed their taxes on her own, that's where those, I think, back taxes came from, that tax liability came from. Because she was not, getting the benefit of filing together, jointly filing as married, which is what their marital status was for the appropriate, or I guess the relevant tax period. And so what I would submit to the court is, talking about something and not analyzing it, is we are then injecting ourselves into the trial court's analysis, which I believe would be improper. Number two, I really don't think that counts as satisfies the second part of the test, because there is no cognitive dissipation of the assets. So you would have to believe Mr. Lewis from 2002 to 2011 was anticipating getting divorced and thinking, how can I wrongdo my wife 11 years from now so that she owes $5,000? And most certainly there's no benefit because he obviously has to pay humongous tax liabilities already. So you'd have to really focus on that alternative second part of the two-part test, which is, did he act intentionally to really dissipate her side or her share of the marital estate? And I think that that's a leap for all the other reasons I stated, and because simply stated, that's not how it was analyzed.
Hey, I'm gonna pause real quick here, because a lot of people get confused. That 5 minutes and 40 seconds is your total time left, so you'll be cutting into your rebuttal time here shortly.
Okay, I did not know that, Your Honor, thank you.
All right, I'll start it up again.
Yep. I would say with issue 3, Your Honors, we're dealing with the credit card statement. What I'll simply put with regard to that issue is that the standard should be a manifest way to the evidence standard, not a abuse of discretion standard as proposed by opposing counsel. The main reason is because it's not a question of whether or not the trial court was using its discretion in analyzing evidence. It's a question of whether or not there's clear evidence that proves what was testified to by the opposing party, as well as to the credit card statement she gave to the court was false. And I pointed to my brief that there was a credit report provided wherein the PNC bank account credit card that was supposedly the opposing parties had no debt at the time of the de facto date of divorce, and the other credit card was not even in her name, not even on her credit report. It was her current paramour's credit card, and he came in and said, this is a debt that I incurred for my girlfriend. When in reality, as of the date of the de facto divorce, neither one of those debts existed. You can't then go beyond that date in a particular issue because it suits the argument that maybe she's entitled to recoup that debt. So with regard to issue 3, I think that's an important distinction. And what I will also say, I believe it's moving on to issue 4, Your Honors, the mortgage balance. And this is particularly confusing, and I want to touch on it briefly. The expression I used was a hindsight sort of ex post facto imposition of spousal support on my client. There was a mortgage balance of about $60,000 in principal as of the de facto divorce date. Opposing counsel referenced filing a motion to modify temporary orders. When you look at that motion, which is a part of the record, there is no request for spousal support. So what is seminal to issue 4 is that there was never an order for spousal support at any point in time, nor was there a motion for temporary orders requesting spousal support. The motion for temporary orders applied to asking my client to pay for extracurricular/school expenses, which is very different. So the issue I have with what the trial court did there, and it's confused me and baffled me the math they've used, but it's almost as if they drew a certain point in time after Mr. Lewis had satisfied the mortgage, and from that date to the time of the trial court said, well, the principal balance was approximately $39,000 when the mortgage was extinguished, or I believe what the court was really trying to articulate is that the time the motion for temporary orders to be modified was filed, the court is saying that mortgage balance was about $39,000 at that point in time, and because Mr. Lewis did not have to pay about $38,000 in spousal support because he preemptively extinguished the first mortgage, that somehow those two numbers should cancel out. And it's similar to what I just stated. Where it really becomes confusing is the trial court improperly deviates from the de facto divorce date and also is imposing spousal support without a temporary motion to even leave that issue open for trial. And so I believe that to be completely improper. I'll wait and reserve the remaining 2 minutes for a while.
Actually, you have 2 minutes and 5 seconds.
Oh, did I say 5? I apologize, right?
2 minutes and 5 seconds total. Okay, Attorney Donor on behalf of the you have 15 minutes, sir.
Thank you. Please support. I am John Donor, and I represent Kristen Elliott-Thomas, the plaintiff at the trial court level and the appellee here. Concerning assignment of error number 1, the 8th District, 4th District, 2nd District, 6th District, and 5th District have all been cited in the appellee's brief as courts who have found that in a divorce, the failure to file tax returns can constitute financial misconduct. Here we have a person who has his own business, keeps those business records close to the vest, as I'll address in a moment, and then has an accountant, a friend of his who's an accountant, prepare tax returns for the parties, supplies those tax returns during the marriage. The first couple he files, the remainder he does not file, never tells the wife he files that, never files the returns. It is not until 12 years into the marriage, in the early part of 2012, that Ms. Elliott-Thomas discovers that there is a IRS issue, and that is because she happened to be home when the mail came, and she intercepted the IRS notice that came to both parties for failure to file.
So let me come back. You mentioned the other districts that both failure to file is financial misconduct. Do you disagree with opposing counsel that the 9th in Beckelo says this two-part test is required?
No, I do not disagree with that at all. I also cite the Beckelo case, and I would point out that there are two reasons that I think that test was met. One came up on the questioning of the appellant's counsel today. My client's late discovery of this, having to file, and then having to pay penalties and interest for the non-filing during that period is actual harm to her. In addition, there's another part that is a benefit to the husband, and that is, as recognized by counsel, cited in my brief, in the Gupta case, the 8th district said, the IRS doesn't guess low, I'm paraphrasing, doesn't guess low. If they're guessing that if you haven't filed tax returns, they are going to get your attention by coming up with a high number. You file your returns, you make that argument that they should reduce the amount of tax liability, and then the consequential penalties and interest. Well, Mr. Lewis did not file his tax returns. As of the date of trial, he hadn't filed his tax returns. He had not done that. He had not done anything to mitigate that. What he is trying to do is take what he said is 155,000 federal taxes and 55,000 Ohio taxes, but he also produced exhibits that showed notice of IRS liens from, I believe, 2013 and 2014 that totaled about $400,000. There was no clear evidence of what this burden was, and tax burden was, and there's nothing in there that said this is what he has done to mitigate that. But he wants the trial court to have to go back and take whatever the IRS is saying. Today saying, okay, it's at 155 federal, 55 state, so let's take that off of the marital estate. Then when this is all over, I will file my tax returns, I will get a lower amount, and I will get the benefit of having those higher amounts considered by the trial court as the amounts of the actual tax burden. I think that's the second part.
Just one last question on that. Did the trial court cite this 9th district case, Beckelo? I understand you're arguing that
Yes.
it applied the analysis, but did the court cite the 9th district in this?
It did not. It cited the 5th district in the Oliver case.
So your argument is that even though it wasn't cited, it was the court analyzed the case pursuant to the 9th district's
I think that-
rulings in this case.
Yes, Your Honor, I'm sorry. I do think so.
Okay.
The fourth assignment of error that was cited deals with this modification of temporary orders. In over 30 years of practice, I have never had a case where the trial court had to appoint a receiver with the sole assignment for the receiver to get the documents ordered from a party. And that's what happened here. Judge Cook took the bench, saw that this case was over 5 years old. During the course of this case, the docket bears this out, we got babysat. It's probably a good way to put it. The court required the attorneys and the parties to show up once a week to explain what progress we're making And we did that at least a dozen times. 4 times I filed motions to compel on behalf of my client, and 4 times those orders were granted, and 4 times Mr. Lewis did not produce those documents. Consequently, this case goes on for almost 5 complete years before we get to trial. What counsel misses is at the very beginning, at the time of the filing of the case in October 2012, Ms. Elliott-Thomas asked for temporary orders, including spousal support. In 2014, she asked for an amendment of those orders that not only included specific requests for relief for expenses for the children, but also for such other and further relief, such as spousal support, because the mortgage was coming, it was getting ready to be paid off. At the time, Mr. Lewis, under the original temporary orders, was making about $140,000 per year, and Ms. Elliott-Thomas was making under $30,000 per year. He was required to pay these expenses. It hadn't changed much in 2014 when she filed her motion, and there's no doubt, had the court not been sincerely absorbed in the discovery problems that we were having, we could have had the temporary order hearing. Instead, that got passed to the final hearing, and that was the argument that was made at trial before Judge Cook, was to use that to offset any benefit. Could have actually been a greater benefit if she would have modified the support award retroactive to when the motion was made, but she did not. She just had it offset the reduction in the mortgage during that time.
And just so I'm clear, we're only talking about temporary support orders. Was there a request for a support order in the final decree?
Originally in the complaint, yes, there was, but we waived that at the final decree, that any post-decree spousal support would be waived. The fifth assignment of error deals with premarital and marital value of the husband's business. I'm going to agree with the appellant on one point in this, and that is, I think the trial court was incorrect in determining the premarital value of the husband's business, but for far different reasons. My client is satisfied with the judgment of the trial court. I will state that, and we did not file any cross appeal on this. But the appellant raised that the premarital value was wrong when the court said it had a value of $90,000, and I agree with that. I agree with that because the trial court used the money, the cost of purchasing the business by Mr. Lewis in 1990, 10 years before the marriage. There was no evidence, 0 evidence, on the value of the business in 2000 when the parties were married. What happened, and what can be a little bit confusing, is Mr. Lewis was divorced in his prior marriage in 1999. At that time, the trial court was not presented with any witnesses, any evidence, or anything concerning the value of his business. But in anticipation of trial, Mr. Lewis's ex-wife, Dana Whitmer, hires a forensic expert to determine the value, hires this man, Louis Maglione. Mr. Maglione is still available. He practices and works internally for a company, but he's still a CPA, still in Erie and Cuyahoga Falls. He was not called as a witness here, but in 1999, in that divorce, on behalf of, not Mr. Lewis, but his ex-wife, he doesn't do a report, he does a letter. And the essence of the letter is, I don't have information. I am going to take a wild guess and say the business is worth this. He doesn't even call it a valuation, he calls it an analysis. There was an opportunity to call at this trial, Mr. Maglione. They did not. There's 0 evidence. That was not admitted by the trial court. And there's 0 evidence of any value. And that was the burden on Mr. Lewis to show that there was value. The Present value is $160,000. There was one expert who testified. The trial court requires, by its local rules, to exchange expert reports in advance of trial. Mr. Lewis declined to get an expert. He had no expert report. He had no one qualified. He called an accountant, his friend who was a tax preparer who had done the taxes for the business and their personal tax returns, called him as a witness, but never sought to qualify him as an expert or have an expert report from him. There is only one, and that was by Mark Bover, the expert for Elliott-Thomas. And we believe that it would have been, if this matter is remanded, the trial court used that value and zero value at the time of the marriage. The last thing I will address is child support. At the time of the trial, the law was the revised 31, well, it's in my brief, excuse me. The child support statute said for cases that the combined income of the parents are in excess of $150,000, the minimum amount the trial court is to award is that amount, which for two children, as in this case, was about $21,700. And that's the minimum. Last year, this court in JM versus LM said it's a case-by-case analysis. That's what the statute says also. And you have to look at the needs and standard of living for the children had the marriage continued. And in 2012, both of these young girls were enrolled in Our Lady of the Elms School. They were both involved, highly involved, in dance programs. The older child especially gifted, but the younger child also involved to a high level in dance. Both parties, father and mother, participated, taking the children, watching the children, making sure they were enrolled at the Elms. That only fell apart once the divorce was filed. But during this long 5-year period, the older child gets to high school age, is accepted in one of the premier ballet schools in the country, the Pittsburgh Ballet Theater. And it is a residential program and ballet program combined. It is an extraordinary opportunity for her to have exposure in the future. Between the two girls at the time of trial, the cost for their extracurricular activities, private school and this dance program for the older child is the lion's share, but local dance, costumes and other things that go along with not just the training and recitals, was just over $48,000 per year. Out of that $48,000 per year, the trial court capped that at $14,750 for the father. He is arguing, well, I should either pay child support or I should pay the extracurriculars, but I shouldn't have to pay both. In fact, it would, if that issue is remanded, it should be remanded with instruction not to treat extracurriculars differently and have father pay less. But you could put it in the child support worksheet as reasonable, necessary expenses for the children to maintain or come close to maintaining their standard of living had the marriage continued, and their participation in these schools and activities would have been with that. Under that, the father is making 65% of the gross combined income. As there's a child support worksheet that has that attached to the decree of divorce. And mother's making 35%. He would be paying $32,000.
You've used your time, Attorney Governor.
Thank you.
Thank you for your argument. And Attorney Concilio, you have 2 minutes and 5 seconds for rebuttal.
Thank you, Your Honor. I'm going to talk quickly, although that's normally been my MO. child support. Council, opposing council and myself are wrong about one point. The trial court, when you look at the worksheet, did in fact count some of the income above $150,000. There's a 10.5%, I believe it was 27,000 over the 150 mark, and they included 10.5% of that as part of the gross income for purposes of calculating child support. Where I will disagree with opposing counsel, when you look at Exhibit K that he cites with regard to child support, the $49,000 is not for a calendar year, it is for 2 calendar years. So at a minimum, you have to have that as being a yearly extracurricular expense. The reason why I've been so, in my brief and sort of animated at the present moment, is because the children don't live at home. They're not living with mom, and dad's paying child support to mom to offset expenses at her house, then also paying for tuition so the kids can go to Pittsburgh and live there full time. So it's a double dipping almost. It's not the children are, living in a situation where they're being denied. It's not, as I think opposing counsel cited several times, my client's desire to not want to take care of his kids. I think common sense would dictate that he is in substantial debt from the tax liability, and he spent 10 years of his marriage taking funds, supporting a lifestyle that he really couldn't afford. So I think the evidence and common sense dictates that this is a man who's not trying to evade taking financial responsibility for his children. And I think it is wrong and abuse of discretion for the trial court to reach in and double dip on extracurricular expenses where he's paying for the child's lifestyle to go to school and also paying mom even though the child's not really there full time. With regard to the financial misconduct standard, I found the component that I wanted to read, which is that whether or not a party omitted and committed such misconduct, whether or not a party committed misconduct is largely dependent on the specific facts of the case. That is cited by opposing counsel's brief. That is the law for misconduct. It's not a situation where we get to apply a black letter rule, and I wanted to make sure the court had that text. Thank you.
Thank you both for your arguments in this matter. The court will take the matter under advisement, issue a decision in due course. Each of you will receive a copy from the clerk's office once the decision is rendered. You can also keep an eye out on Supreme Court of Ohio's website where the opinions are posted. Thank you again for your arguments.